back to Trade Talks Live, the show where we break down big trade topics. I'm Isuri and with me is Pasali. Today's focus is the WTO Agreement on Trade-Related Aspects of Intellectual Property Rights, better known as TRIPS. It's a cornerstone of global trade law introduced in the Uruguay Round and enforced from January 1st, 1995. TRIPS was the first WTO agreement to incorporate intellectual property into multilateral trade rules, setting a minimum global standard. For example, under TRIPS, each member must protect copyrights, patents, trademarks, and even trade secrets across nations.
That's right. It's a big deal for innovation and business. TRIPS is essentially a minimum standards agreement, meaning all WTO members must at least meet its protection and enforcement rules. In practice, that means a national law in one country can't offer weaker IP rights to foreign nationals than to its own citizens. On Trade Talks Live today, we've got a panel of experts. We'll interview them segment by segment on TRIPS background, objectives, core provisions, and some landmark WTO dispute cases. Let's get started.
Hi, thanks Isuri. Thanks for having me. So at its core, TRIPS arose from a long debate among developed countries and developing countries. Developed countries wanted stronger IP protections worldwide, while developing countries feared it could hurt their access to technology and medicines. In the end, TRIPS was adopted as part of their single undertaking of the Uruguay Round and became binding with the WTO's founding. Its purpose was to harmonize IP laws and enforcement globally, covering copyrights and related rights, trademarks, geographical indicators, industrial designs, patents, layout designs of integrated circuits, and protection of undisclosed information. By requiring national laws to meet these standards, TRIPS aims to balance IP rights with trade interests. TRIPS explicitly links IP and trade. It promotes technological innovation and technological transfer to the benefit of the producers and users of knowledge, quoting the WTO, in a manner conducive to social and economic welfare and to the balance of rights and obligations. In other words, TRIPS was meant not just to lock in rights for inventors, but also to encourage sharing of technology and access to knowledge. In practice, when it was negotiated, many developing countries worried it would limit access to medicines or seeds. This debate even produced the Doha Declaration of 2001, which emphasized that TRIPS should be interpreted to protect public health and promote access to medicines. Over to you, Sudeepa.
Good morning everyone, I'm Sudeepa Suchai and today I'll briefly highlight the main objectives of the TRIPS agreement as outlined in Article 7. At its core, TRIPS aims to ensure that intellectual property protection contributes to both innovation and the dissemination of technology. It's not just about giving rights to creators or companies, but it's about balancing those rights with the broader goal of social and economic welfare. The agreement specifically mentions that IP protection should work to the mutual advantage of both producers and users. This marks a shift from earlier IP treaties which focused mainly on protecting right holders. With TRIPS, the intention was to make stronger global IP rules that support economic development. One of the key goals is to promote technological progress. By providing incentives like patent protection or copyright terms, TRIPS encourages companies and creators to invest in research, innovations, and creative outputs. Another major objective is to facilitate international trade in knowledge. With a common IP framework, businesses can operate more predictably across borders. For example, if both countries follow TRIPS, a patent granted in the US is more likely to be respected abroad. Finally, TRIPS also allows for public policy flexibility. Article 8 recognizes that countries might need to protect public health or nutrition. That's why, under certain conditions, they can issue compulsory license or allow parallel imports of generic drugs, especially during health emergencies. In summary, TRIPS is not just about enforcing IP rights, but it's about creating a balanced system that encourages innovation, support development, and respect public interest. Thank you.
Exactly, Sudeepa. So now let's look into the key provisions and WTO principles. One of the fundamental WTO principles reflected in the TRIPS agreement is national treatment. This is covered in Article 3 of TRIPS, where it requires that a member must treat nationals of other members no less favorably than its own nationals with respect to IP protection. So, for an example, a French inventor and an American inventor should have equal intellectual property rights in France. The WTO borrowed this principle from the Paris and Berne Conventions for intellectual property, but TRIPS applied it across the globe. Closely related to this is the most favored nation principle, which is mentioned in Article number 4. Any advantage given to one country's nationals must extend to all its WTO members. So you can't just carve out special intellectual property deals for a few partners. TRIPS extended these principles to intellectual property endorsements too, for example, civil court cases and border issue rules. This emphasis on non-discrimination ensures TRIPS aligns with the core WTO rules. It prevents a country from favoring its own inventors or certain foreign friends over others. Finally, I'd like to say TRIPS intertwines intellectual property with WTO's non-discrimination and transparency requirements. So intellectual property rights do not become hidden trade barriers. So that's all from my end. I'd like to pass the mic to Mr. Isuru to talk about the salient features of the TRIPS agreement.
Hi, I'm Isuru Marasinghe, an IP enforcement expert, and today I want to talk about TRIPS, the agreement on trade-related aspects of intellectual property rights. It's a game changer in global IP law. What makes TRIPS so unique? First, it's huge. 73 articles covering everything from copyrights and patents to software, databases, and even plant varieties. But it's not just about setting standards. TRIPS require every World Trade Organization member to pass real, enforceable domestic laws, and it takes enforcement seriously. Civil and criminal penalties, custom checks to block pirated goods, and even emergency court measures like injunctions. Here's the real kicker. If a country violates TRIPS, others can take it to World Trade Organization's dispute settlement body. That means legal action, panel rulings, and yes, even trade sanctions can be taken against such countries. Yet, TRIPS is not inflexible or rigid. It sets minimum standards, but lets countries go beyond them. For an example, developing nations were given extra time to comply, especially when it comes to sensitive areas like pharmaceutical patents. And don't forget Articles 7, 8, and 30. They are all about the balance. They allow narrow exceptions like famous BOLA exception, which lets generic drug makers start preparing before a patent expires. Finally, TRIPS is where intellectual property meets global trade, and it has reshaped IP landscape worldwide.
Hi, I'm Leslie, and I'll be talking about one landmark case for patent protection for pharmaceuticals, which is India Patent Protection for Pharmaceuticals DS-79. The US challenged India for not meeting its TRIPS obligations. At that time, India only offered process patents, not product patents for medicines. Under TRIPS Article 70.8, India had to allow filing of patent applications for drugs, and Article 70.9 required granting exclusive marketing rights during the transition period before 2005. However, India had no proper legal system for support this. The WTO panel found India in violation because administrative guidelines alone didn't fulfill TRIPS obligations. This ruling forced India to change its national law and eventually introduce product patent protection for pharmaceuticals. It was a landmark decision that clarified how seriously WTO takes transitional requirements under TRIPS. Even procedural gaps can lead to non-compliance.
Let me explain this case study, the EC Geographical Indications Dispute. This case involved US and Australia challenging the European Union's GI rules under WTO dispute cases DS-174 and DS-290. The issue was that foreign producers couldn't apply for GI protection directly in the EU. Instead, their governments had to apply for them, and only if those governments had the same kind of GI system and protected all EU GIs in return. This was seen as unfair, especially to non-EU countries. The WTO panel agreed that and found that the EU rules violated TRIPS Article 3, which says all WTO members must be treated equally. That's called the National Treatment Principle. It also affected trademark protections under TRIPS Article 16 because the EU GI system made it harder for foreign trademark owners to defend their brands. As a result, the EU had to change its rules to give fair access to GI protection for non-EU producers. This case matters because it's reinforced that GI systems must follow TRIPS rules, respect trademark rights, and treat all WTO members equally, even when protecting cultural products.
A shorter but important case in the US Section 110 subsection 5 of the US Copyright Act is this case which dealt with the US copyright exemption that allowed podcast music to be performed in small businesses without a license. But other countries stated that these exemptions were too broad to be qualified as limited exceptions under the TRIPS Article 13. Article 13 requires that copyright exemptions to be confined to certain special cases and to not conflict with normal exploitation. The WTO panel agreed with the complaints, and it also found Section 110 subsection 5, Section B, the business exemption, was a broad de facto exception, and it went beyond the narrow clause of US negotiators. In short, the panel held that this US provision conflicted with TRIPS. The United States responded by amending Section 110 subsection 5 in 2001 to narrow those exemptions. This case is a classic illustration of TRIPS Article 13's strict special cases. An exemption simply allowing any store or restaurant to play radio or TV broadcasts without paying was far too reaching. It helped define the scope of legitimate exceptions, saying that you cannot have a blanket free use rule if it undercuts copyright owners' rights.
For the final example, we have Canada patent protection of pharmaceutical products. The European communities challenged the Canadian rule allowing generic drug makers to stockpile and even sell patent drug substance up to 6 months before the patent expired, which is also known as the BOLA exception. The EU said this violated TRIPS Article 28.1, which is the patent rights, and Article 33, which is the patent term. The WTO panel conducted a detailed analysis under Article 30, which is also known as limited exceptions to patent rights. It concluded that Canada's exceptions was not a limited exception, it was actually a substantial curtailment of patent owners' exclusive rights. In other words, by allowing generics to be made and sold so early, patent holders nearly lost half a year of exclusivity without compensation. The panel famously said the BOLA provision went beyond what Article 30 permits. It would have substantially curtailed and exclusionary rights of patent owners and so violated the Article 28.1. Canada was advised to amend its law. This case set important limits on TRIPS exceptions. Even public interest exceptions like health-related BOLA uses must be narrow. It confirmed that TRIPS does not allow a member to completely undermine patent terms via bold statutory exceptions. This is what the example of Canada patent protection of pharmaceutical products entailed. Thank you.
And that wraps up today's session on the TRIPS Agreement, a powerful bridge between innovation and international trade.
We hope you enjoy diving into the world of intellectual property with us. Remember, knowledge shared is knowledge multiplied.
Thank you for tuning in to Trade Talks Live. Until next time, stay curious, stay global, and keep those ideas protected.
Goodbye, everyone, and happy trading.